This is time for a special master hearing in the various coordinated Wren cases. The elite case is case number A21831-776-B. We are being reported through Zooms, and I have instructed the court reporter to let me know if there's any problem with the record. So would you please, you folks on Zoom and you people, as the Reno judges would say, here in human form, as opposed to your alien form, identify yourself before you speak. So the first thing I want to cover, which I think is no dispute on, but as you know, we received a order setting a trial in the Hunter Brown case for a firm date on October 7, 2024, and I received a stipulated order regarding discovery deadline signed by Judge Williams. So I'm assuming that's complete. No one has anything to add to that. We can just consider that issue taken care of. Any objections or any discussion we need on the discovery schedule and the trial date in the Hunter Brown case? Okay, thank you. Then I think I'm going to go a little out of order here, I guess. There was an issue regarding the IME, the NRCP 35 examination that's being conducted. Who's the plaintiff on that? I know there's, is it Way?
No, they've asked for, or Eric Pepperman for plaintiffs. They asked for IMEs from Hunter Brown, Shea Rasmussen, and Carla
Marino, right?
They asked for Pam Brown as well, but Pam Brown has had a medical issues that, that's on our agenda. During her deposition, she had to cut it short because she was feeling off. Subsequent to that, she was, diagnosed with a medical issue, and her doctor has not cleared her to participate in her continued deposition, let alone any type of Rule 35 exam.
Which witness is that?
That's a plaintiff, Pam Brown.
Oh, Pam Brown, because the letter I have regarding the IME is Sherry, that's Cheri, Rasmussen, Carla Marino.
Well, do you have this June 28th one?
I have what?
June 28th letter.
And who was that speaking?
I have the July 1.
This will Kemp. Sorry.
This is Laureen Frister. So the IMEs we're requesting are for Pamela Brown, Hunter Brown, Shea Rasmussen, Carl Moreno.
Oh, so Hunter Brown, yeah, I didn't. Okay. And the issue is whether someone can witness and record that?
Well, there's two issues. One is an observer and someone recording during only testing portion. We're okay. We've reached agreement as to the interview portion. That's okay. That's recorded. And then the second issue is the length of the IME exam.
So the interview portion recording and the observer has been agreed to under the new rule.
Right.
What's the issue on the length now?
Well, no. Well, the first part, so it's a two-part exam. It's interview and then psychological testing. So ethical rules prevent neuropsychologists from agreeing to recording or observers of the testing portion. And that leaves the defense hamstrung because we can't get an opinion from a neuropsychologist without the interview and the testing. Well, we cannot find a neuropsychologist in the country that will allow recording of the testing portion.
Is it all verbal?
I honestly don't know. I don't want to guess.
So what do we do about that if we can't get anyone to agree to it?
Law's the law, Floyd.
Yeah, I mean, this is the law. They don't dispute that it's the law. The law specifically allows for the recording of the whole thing. And it appears that they haven't even really consulted with the expert on this, because my understanding is that these testing are in writing. And
That's what I thought, but to be honest with you, I just have always assumed that.
And I've assumed
I don't
that
know.
too, Floyd. I just can't say 100% that there is no verbal portion of it. I assume that some of it is verbal. Otherwise, they would say, go ahead and audio record.
Who's the neuropsychologist?
So the one that we have retained, his name is Jed Gunter, and I've spoken with 7 total neuropsychologists.
Yeah, Floyd, this Will Kemp. If you remember, we had a similar issue come up a couple months ago with Dr. Sands and Dr. Edkoff. And what was agreed to there, if I remember right, was the written questions that Dr. Sands did went to Dr. Edkoff, and he used those, the data, sent the data one to another.
Yes, they do typically share raw data only with other psychologists and neuropsychologists. That's not the issue. The issue is that they will not consent to an observer or audio recording or video recording of the testing.
Well, if we're willing to give the raw data, why would they need to do their own raw data? I don't understand that.
I don't understand that argument.
Last time we did the raw data with Dr. Sands, we gave it to Dr. Edkoff, and he gave his opinion based upon the raw data, which was the same thing. He said it was the same thing he would have done. So, I mean,
okay, so are you saying that your expert already has raw data from all these plaintiffs?
We can get you raw data for some of the plaintiffs. Specifically, I think we can get Hunter Brown, Sherry Rasmussen, and Carla Moreno. Pam Brown, I don't know about. Okay, so the 3, we can get you raw data. I don't know exactly when, but I think we get you raw data.
Okay, and we're coming up on the expert deadline in a week or so is another issue.
Well, it sounds like there's actually been movement since the letter I got Friday on this. We'll extend the deadline to accommodate the 2 of you trying to work out an agreement.
Okay, I'm happy to work out an agreement. I have to talk to my expert to see what tests he would have run and to see if that will match up with the tests that their expert would run, and if my expert can rely on their raw data.
I would him not be able to rely on it. Dr. Edkoff can rely on it. Why don't we do this?
I hate to age him, considering my age, but he goes back a long way.
Right, he goes back a long way.
Yeah, but the only thing good, this is Teddy Parker for the record. The only thing good about this is Edkoff actually trained or was a mentor to Gunter.
That's true.
So I cannot imagine why Gunter would not rely on the same type of raw data that Edkoff did.
Why don't we do this? Why don't we talk to Dr. Sands? I think we can talk to him today, if not today, by noon tomorrow. And we'll confirm that he has the raw data, which I'm 99% sure of right now, and what day he can provide it. And I would hope he could provide it by the end of the week.
And once he provides it, well, we don't know which expert she's going to use now, though, right?
I thought she said she was going to use this.
Jed Gunter.
I am like, well, I need to check on his availability. As long as he tells me he's available to still work on this case, I am going to use Jed Gunter. And I was not part of that prior case where that involving that issue with Dr. Edkoff. I don't know if Dr. Edkoff agreed to rely on the raw data for some other reason. I have no idea. So I don't want to.
Well, why don't we let your expert decide that?
Okay.
So,
Yeah, that was Milwaukee's expert, Floyd. If she wants to circle up with the Milwaukee Council, I think.
And Real Waters had an expert, Dr. Bailey, who did the same thing.
Dr. Bailey was for minors.
Well, I'm just saying it was.
Yeah.
why don't we do this? We'll get the data. Actually, they actually have to have the doctor convey it to the other doctor.
Yes.
Right.
So let Will know which psychologist you're going to use, and then his expert will send your expert that data, see if they can work together. And if there's an issue, fine, but it worked out fine the last time.
Okay, and it's also a matter of my expert getting the data for the test that he wants to run. If there are tests that he wants to run that Dr. Sands didn't run, then Dr. Sands should also run those tests.
I recall right, it was a standardized thing that Dr. Sands did. It was the same standardized thing that Dr. Etkoff was going to do. So.
Well, we have different plaintiffs with different neuropsychological
but
issues, so there might be different tests.
But the experts used a standardized test. So,
Well,
see if the two experts can work it out. And, you know, I mean, we've made a giant leap from last Friday. So if it can be resolved, I'd rather it be resolved by the experts than us.
Okay.
So let's see if they can work it out. And particularly before the exam, the two experts could talk to each other and try to resolve this.
And Floyd, I don't know if you remember, but last time we agreed to a continuation for Dr. Etkoff's report to come in late. I don't think we're at that point yet, but if that's where we need to go, we have the same position. We don't mind a brief continuation.
No, I'm going to work with counsel on that.
And then the second issue was the length of the exam. Obviously, I don't know what portion of the 8-hour day was for just the interview and what portion was for testing. But plaintiffs are arguing that the entire exam, interview and testing should be limited to 4 or 5 hours. I spoke to 7 experts. The shortest one is 8 hours. So I don't see how we can limit it.
How can you know how long an exam will take just generally? It's the individual, their claim damages and issues.
Well, wouldn't it be more difficult to learn to know how short it would be?
Yeah.
Well, it depends what testing they want to run or what the damages are that are alleged. I mean, our expert is doing these in less than 4 hours. They have given no good cause whatsoever for anything longer than 4 to 5 hours. I said, we'll work with you to schedule a time. If you want to make it more than 4 to 5 hours, what's the good cause? How long do you need to interview these people? What kind of questions do you need to ask them that it's going to take 5 hours?
Why don't we go with 6 hours? And if your expert says that can't be done, let me know with the other issues.
Are you limiting it to 6 hours for interview and
Everything.
testing? Or okay, so if we resolve the testing portion and they're just relying off of raw data, then is the interview still limited to 6 hours?
It's not 6 hours for the interview. It's 6 hours for everything, unless your expert can give you an affidavit saying that's not sufficient. And then I'll look at it.
Okay, and like I said, I don't know how long the interview portion is. I'm sure it depends on what.
6 hours total right now. If for some reason that doesn't satisfy your expert, whoever your expert is, we don't know yet. If you want to bring that, I'm going to have to see dueling affidavits from the doctors on why that is sufficient.
Okay.
And then Floyd, we still have this issue of Pam Brown. First of all, she can't do any interview right now. But second of all, there's no way she's ever going to be able to do 6 hours. So,
well, Pam Brown, I'm waiting to find out if she's even going to have to submit, right?
Well, right now, what we're trying to work out an arrangement with the defense taking the deposition to finish the deposition on written interrogatories. So we're hopeful that can be done. But assuming that's the case, we still have the psychological weakness.
Well, I need to hear from her treating physician that she can or cannot do it, or why.
We've already given the records on her having a stroke. Well, we can do that. She had a stroke.
It's not a stroke.
Did I get a record on
No,
that?
you didn't get a record. We just gave it to the opposing counsel trying to work this other issue out.
Well, when you can't work it out, let me know.
Okay.
We'll get everybody back together. That was just a test to see if I really read this stuff.
Right. Yep.
I think this is a good time then to address the issue of Pam Brown and whether she'll ever be able to sit for a deposition, or plaintiff's proposal that she should submit to written questions.
I thought you said you had an agreement on the written questions.
I said we've been trying to work this out with opposing counsel. We sent a proposal to them. We haven't got a response back from them.
Right, and the response.
Okay, do they have records? Is there something they have they can look at?
I don't know. It sounds to me like the response back is screw you. So
Mr. Hale,
I think if we can brief this, we should brief it, but it's not up for.
Well, why don't you provide them with your position with supporting documents, and if they oppose it, they can oppose it. You can get the stuff to me and I'll rule on it.
Okay.
Special Master, this is Shea Backus for Albertsons and Sprouts, appearing on behalf of Jack Burden. I can announce it. I can respond to this. We started the deposition. Jack started it, and we were agreeable. We're agreeable to do the examination by interrogatories. However, I didn't want to speak for any other of the defense attorneys, but on behalf of our firm and those two clients, we're okay doing the written interrogatories for like the written deposition questions to finish off the examination that we started. But I was not able to do it.
Shea, is there a continued date yet?
We had agreed to a date, and then what had happened was she was unable to appear due to her current medical issues that occurred. And we received correspondence from counsel about that.
All right. Is there anyone that objects to finishing? Is it Pam Brown, right?
Pam Brown, just
Pam Brown's deposition by written interrogatory.
Yes.
Why?
Well, when she appeared, she had a blood pressure cuff on. It was just slightly high. That from what I've seen from her doctor, she didn't have a stroke. And the doctor's note doesn't say that she's not going to be able to appear ever. It seems like he's not sure what her status is. So until we find out what it is, then.
Do you have records from a doctor that say she can't?
We can get, I talked to the son this morning myself, so I think we can get more records if they need them. I'm more than happy to do that.
All right. Well, why don't you get records, and then the two of you let me know if there is no agreement on it. I'm going to lean. I'm not going to have somebody have a stroke.
I don't want her to have a stroke during her deposition, but we'd just like more information.
What's that?
I don't want her to have a stroke during her deposition either, but I would like to depose her, and I would like some more information before agreeing that.
Oh, and you're going to get it.
Okay.
So just let me know if it can't be worked out. Let me know.
Okay.
Well, can I, for clarification, what additional information you want? I mean, we provided the doctor's note saying what happened and that she can't attend the deposition. There's no way to know when she may be able to. We don't know. We just don't know that information.
This is the doctor's note, just for the record. It's Will Kemp again from Premier Urgent Care, dated 6/24/24. This is to certify that Ms. Pamela Brown is in my care. She recently had a hyperintensive crisis causing TIA. Due to recent episodes, she is not cleared to attend the deposition at this time. That's from Dr. Richard Tay, TEH.
So Dr. Tay is not a specialist. He works with the urgent care. He's a family practice doctor. So I'm sure she will be treated with a specialist.
That's sufficient. A general doctor saying that's sufficient. If you have an opposing.
And it also says at this time. So, I mean, maybe next month she'll be fine.
Okay, I'll give you a week to respond. You've already been given this report.
It's not a report, it's a letter. But we don't have
signed it.
Yes.
And that's not enough for your client.
Well, I mean, she just went to an urgent care and is having the family practice doctor from the urgent care say that she's not available at this time. Things can change.
I'm going to require the rest of the Pam Brown deposition to be by written interrogatory following the responses to those written interrogatories. If there's still an objection and a request that she appear in person, I'll consider it at that time. That way you can look at the written interrogatory responses and tell me why it isn't good enough.
Okay, and are we limited to a specific number?
To what?
Are we limited to a specific number of interrogatories?
I'll rely on your discretion unless I get an objection.
Okay.
Now, it's probably obvious to all of you. I take it she's going to be in the October 7th trial.
Yes. God willing.
So why don't you get those out as soon as you can? And that way I'll have time before the trial resolved if you want to come back here and ask for it in person.
Okay.
And Floyd, no, we're not asking for a full 30 days to get the answers back. We can do them in 15.
Okay, thank you.
I'm going to assume you two can work it out. I'm not giving any time periods because there might be some back and forth. Just somebody let me know when I need to bring it up in the hearing again. I think that's what I had on my initial agenda. I received a proposed agenda that was filed on June 28th. I thought it looked like most of these things have been resolved on topic one, which was production of documents. Is there? It was a discussion, and we covered Carla Marino.
These are the slides.
Yeah. This is a report, and I got to think about it, and I can make a request on top of that. So in the Brown case, we have 15 plaintiffs. 6 of them have slides.
There's 16 plaintiffs.
There's 15 plaintiffs.
15, and was 6 with slides.
6 have slides. One of them is Mr. Henry. Those slides were produced months ago. They've already been subject to 2 expert reports by our pathologist, and they were given to Dr. Gong, the UNFI pathologist, months ago. So that's not a problem. And again, Mr. Henry is the one that had the liver transplant. The other 5 people are Moreno, Moreno, Ita, Ittah, Randy Wren, Wren, Monica Branch Noto, Noto, and Daisy Wei, Wei. So those 5 people all had biopsies at the time of their hospitalizations. And these are the tissue samples we're trying to get now. They break down into 2 major groups. One is the IORA group. That's IORA Diagnostics, has 3 of the tissue samples. And then the other 2 is Quest Associated Pathologists. Okay. And we've been on this for the last 2 months. So I don't want the impression to be created that we just got on this late. We've been trying to get these for the last 2 months. And here's the status. Carla Moreno, we've been promised them. I thought we were going to have them today. We have them. I don't think we have them today, but they're being shipped. And each one, when it says shipped, it means that they're Federal Express to us because they want a chain of custody. So we've cut them the check. They promised them, and so I think those we'll have sometime this week. The Ita and the Wren ones, same thing. They're supposedly a day or 2 behind, but I'm not anticipating any problem. I'm anticipating as we sit here now that we will have all 3 of those sometime this week. So when we get them, we send them down to Dr. Datnow, our pathologist in San Diego. He takes a look at them. He usually makes some kind of blow up from some of the tissue, and I can't remember what it's called, but it's a big picture. And then he sends them to the designated defense pathologist, who has been Dr. Gong. I don't know if there's going to be someone more than Dr. Gong. But so what our intent was to get the tissue slides to Dr. Datnow, have him look at them, and then have him send all 5 to Dr. Gong. So the hangup we have is on Noto and Wei. So we've been in communications with Quest, and I've got one of the emails from our paralegal to Quest. So Quest has basically told us that they're not going to cooperate. They said, go file a subpoena. So we 2 or 3 weeks ago, we filed notice of intent to file a subpoena, waited the 7 days, and there's a subpoena out right now for them. No one objected. The subpoena is due on July 16th. They've already told us they're not going to comply with the subpoena, and then we have to go get a court order, and then they're going to go to court and they're contested. I have no idea why this is their position, but that's what they told.
This is Quest?
Quest and a associated pathologist. So I was thinking if we have to wait for July 16th for them to not comply with the subpoena, and then we file a motion to compel, even on an order shortening time with you, I mean, we're talking about pushing this thing out till.
Oh, you go straight to Williams or somebody.
Well, what I was.
They're not gonna, I've had this dispute before on subpoenas. You need a district court judge.
Okay.
I have the authority to do it, but it doesn't look as good to
Well, here's
people
what
that are contesting.
Here's what I would ask, and I think I know some of the defendants are on our side on this in terms of timely production is better than late production. So what I would ask is that at least you move the compliance date for the subpoena from July 16th to July 5th. And we'll send them notification that they have to, because they're not going to comply with the subpoena by July 16th. So why sit here and wait for 11 days for them to, thumb their nose at us? That way we can file the motion with Judge Williams sooner.
So what deadline do you want?
I just want the two subpoenas moved up from July 16th to July 5th.
You really need me to do that, Don?
Thank you.
But to enforce the subpoena, go directly to the court. I've had that Rule 45 issue before.
Yeah, I'm just Monday when I have nothing from them, I will just file the motion with Judge Williams and it'll be his bailiwick.
And Quest has been involved. So much litigation. I can't understand why we contest this.
I think what's going on here is it's an HMO thing. So what I mean by that is they're not getting paid as part of the standard HMO fee for this work. So they don't want to do it. So it's easier for them to say, screw you, go to legal, than it is for them to do work that they're not getting paid for. And I wish they'd just tell me we want another $1,000 or $2,000 because we pay them. But they don't do that. They just say, screw you. I think that's what's going on.
Do whatever you have to do to get it from the Judge Williams.
Okay.
Joel Odou for Real Water, just real briefly. I have no problem with what the plants are requesting on any of that. We do have our own pathologist. He's in San Diego. And I'd like him to look at the tissue samples one way or the other, and I'll work with plaintiffs to make that happen.
Yeah, that's fine with us. We'll probably have that done before we ship up to Judge Dr. Gong, because Dr. Gong is in USC, I believe.
Yeah, my guy is in La Jolla.
Yeah, so we can have him and Dr. Dadnow network or something. Not problem.
Excuse me, this is Jim. Does that include Taquante Henry's samples as well?
Okay, Taquante Henry slides, we sent them to Dr. Gong. I think she sent them back to Dr. Dadnow, and I think he might have sent them back to us, but I'm not positive on that. But if you have someone you want me to get them to, let me know who it is, and I'll get them out to him.
Same person, Dr. Howard Robin in La Jolla.
So your person.
Will be Jim's, I think. Unless Jim's got a different.
Yeah,
guy.
why don't you guys send Eric an email tomorrow with who it is, and we'll get it out to you.
Thank you.
Where are the original?
This is Noushan Noureddini for Costco. Mr. Kemp, are you certain that Dr. Gong received the Henry slides?
Yeah, I'm pretty sure because I thought she has them in her report. Remember in the last report for the last case, she has a copy.
I think she in the last case, she just looked at Lila Cave. So that's why.
Well, no, but she said, yeah, this is different than Henry. And
Hunwardson.
Yeah. Oh, okay. I might be mistaken. Hunwardson, she says it's different from.
So do you know where are the slides presently?
Henry, I might have been mistaken this with Hunwardson, so I back up everything I said on Henry. So let me try to find out where Henry is.
Okay.
I thought we had Henry, but I'm not positive.
All right, thank you.
Hunwardson, I know we've got.
Where are the tissue samples?
Usually what happens is they have paraffin blocks in each one of the path labs, and they chop a little bit off, and this is the slide they give to us. So the paraffin blocks typically are retained in the path lab.
At Quest.
I don't know if it's either in Quest or it's in the hospital itself. I don't know. Okay.
So the only lingering issue on that is the expert disclosures. Obviously, we need to have all this squared away before we produce just the pathologist experts. So we could just work together, me and confer on a continued date for that.
You can tell me what the agreed dates are.
We might get it in on time. I mean, there's still hope,
Well,
but
just let me know.
okay.
Just at some point, give me a request. And if you can join the request saying, ours will be this date and theirs will be that date, just let me know.
So hold on, Teddy Parker again for the record. That now gets those slides. He does whatever he does, but eventually we need to get it to Dr. Hudson. So Dr. Hudson's report is also an issue when
He
it
needs
comes
to get
slides.
Dr.
Dadnow's report,
Right.
exactly.
Right.
So that's also affected.
Fair point.
All right.
Yeah, let's see where we're at, and we'll talk to Joel about it and see if we think there's needs to be a week or two bump. I'm hoping not, but maybe.
Yeah, that's fine.
Because I'd rather you set the dates than me.
Yeah, no, we'll agree on that. It's just logistics.
All right. And then there was an issue. I don't know what the issue is, just the topic. Kehe late production.
Yeah, so they told us that the reason they were producing documents at this late point is that and they said this to you, that they wanted to be sure that Real Water had produced, they thought Real Water would have produced it all, but just in case they were going to produce it all. So that was pretty strong indicator that they were talking about communications with Real Water. So now they produced, I don't want to say 70,000 documents, but I've heard figures 50, 70,000. They produced a lot of documents. And we've started going through them because we had 2 depositions last Monday. And a lot of these documents are not communications or invoices with Real Water. They're internal Kehe documents. And so there is no reason those should have been produced at the initial 16-1 or at least long, long ago. So we're just digging into these documents. And I just wanted to put it on the record right now that I don't think what was said was fully accurate. And we're reserving our right to file an appropriate motion for sanctions if we deem it appropriate. But the suggestion that the reason there was not a production earlier is because they were relying on Real Water to produce these just cannot apply to internal Kehe documents.
Laureen Frister. So I don't believe that's what my co-counsel Zap said at the last hearing, but I'm going to defer to her because she knows about these documents and I don't really.
Well, I do remember there was an issue raised that the Real Water production would contain a lot of their records.
I remember something said about that, but I don't recall. And so I'm going to defer to Caitlin because she's familiar with the documents.
It's not an issue yet anyway.
Okay.
Okay, then on Terrible Herps, we just wanted to report where we're at. We went out there. I think Eric went with our computer guy and met with the Terrible Herps computer people. And they had what I would call a preliminary meeting where they described the computer system, how it was set up, where the servers were, and that happened a week ago Monday, was it? I believe so. A week ago Monday, and they're following up on it. So that is in process, but that's really all there is to report.
Well, did they give your expert access to the computer?
Well,
what was on the computer?
It was kind of a touchy-feely meeting. This is what our computer looks like. This is the kind of program we run. This is how many servers we have. This is on the cloud. This isn't, that kind of thing. So there was no actual, let's go look.
But they're still working together.
They're working together, and we'll see where it goes.
On Friday as well, we did have a follow-up Zoom meeting where they logged into their Applause Network program and were able to show us that web interface. And then my understanding is they're making images of various servers and computers and file sharing systems. And then those are going to be made available for our expert to run searches on, subject to an agreed upon protocol, which we're working on the details of right now.
But they know what programs are involved.
Yes.
So if your expert needs to download some program, at least your expert has an idea what program is searchable.
We're getting an idea.
Yes.
All right, what's the issue on scheduling for Bonor?
So that is the next trial after the October 7th Brown trial. It's another trial in front of Judge Williams, 3 consolidated cases. Trial set for February 10th at the moment. We do not have an agreed upon scheduling order yet. The most recent dates that we proposed included general experts disclosed on October 28th, case-specific experts November 11th, rebuttals for generic November 15th, rebuttals for the case-specific experts December 2nd, close of discovery is December 20th, and dispositive motion deadline is January 3rd, 2025. Real Waters agreed, plaintiffs agree on these dates. He proposed the close of discovery of 12/20 and the dispositive motion deadline and motion to eliminate deadline of 1/3. However, there seems to be an objection from Kehe regarding the expert disclosure dates.
Well, that's terrible, Herbs.
That's Kehe.
Oh, who's ETT1?
Terrible Herbs.
Okay.
Yes.
So who's the objection from? Oh, Kehe.
So the only problem with that, I proposed dates first, which had the expert deadlines wrapping up in October. And I understand plaintiffs want to move the deadlines back because they'll be busy with the Brown trial. But with the proposed dates received from plaintiffs, it only gives us 15 business days between the last expert deadline and the close of discovery. And then it only gives us 6 business days around the Christmas and New Year's holidays to file motions in limine and other dispositive motions.
And their dates were, if my notes are correct, make sure I have this right. The general expert deadline would be October 28th. The case specific would be November 11th. The rebuttal for general was November 15th, and the rebuttal for case specific was December 2. December 20 closed discovery, and the motions are January 3.
Right. And I mean, let's step back a little bit. This will be the 3rd trial Judge Williams has done, because he did the Gallagher case, he's doing the Brown case, and now he's doing this case. So I think we have a pretty good feel for where he's going on a lot of these motions to eliminate. And so in some cases, they get filed anyway, but they know the result because the ruling is unlikely to change from the first 2 rulings.
What's the trial date?
February 7th, or is it 10th?
February 10th.
February 10th.
That's right. You said that.
Yeah, so I think the big thing that really needs a lot of work is case-specific expert depositions. That's what I think is really what happens, because in this last case, when we just tried the generic, so-called generic experts, it really wasn't much effort at all. I mean, I didn't take half of them, and they didn't take half of ours. The ones that were taken lasted 45 minutes to an hour. So it's really the case-specific ones, like Dr. Datnow and Dr. Hudson, really, and then their counterparts to those.
Are there 2 for each side?
Usually there's, we have a hepatologist and pathologist, and there may be a little more on the site.
And their reports are November 11th.
Right.
Simultaneous disclosure.
Simultaneous.
And then the rebuttals are December 2.
Right. So I think.
And then the trial is 3 months later, but it goes through the holidays.
Right. So you have January and first 2 weeks January to do the depots if you need to kick them back that far. And again, Dr. Hudson will have been deposed at least 3 times by then, testified 3 times by then. I mean, there's no need for background questions for sure.
Floyd, let me just add 2 things to this. Number one, the Bonner et al. Trial on February 10th, I think there's about 14 or 15 individual plaintiffs in that one. Only 1 plaintiff has a claim against Kehe. They're 1 plaintiff, that's it. All 15 we have to account for our experts, and real water has to account for. So the fact that we agree on the 15 or the 15, I think should be given more weight than the one plaintiff that Kehe is complaining about. Number two, this proposed schedule, it's almost identical to the schedule that we agreed to in this case right now. We have the specific disclosures due on July 15th, rebuttals, I think like 2.5 weeks thereafter, and discovery closes on August 23rd, and dispositive motions in limine are due on the 26th. I mean, it's the same schedule. There's 5 plaintiffs who have claims against Kehe.
Well, if 14 out of the 15 agree to this, what I'll do is I'll go ahead and order this schedule.
Well,
but we'll have to be flexible anyway when you get through these reports for scheduling of these experts anyway.
Well, Floyd, I took a laboring oar of proposing deadlines to plaintiffs. From my understanding, the other defendants in the case agree that these deadlines are very tight and don't want only 6 days to file pre-trial motions and 15 days between the last expert deadline and the close of discovery. So it's not just, we're not only concerned with the one plaintiff that's asserting claims against Kehe. I'm speaking on behalf of all the defendants.
So,
and Floyd, Joel for Real Water. This is the 5th Real Water case to go to trial, so I'm not sure why we're killing ourselves on the holidays trying to cram in motions, limine, depositions, and all of that stuff to try and meet a January 3rd, file everything deadline. It's the 5th trial. It just doesn't, and it's with Judge Williams, and Judge Williams is not keen on us killing ourselves over the holidays because I just not doing about that. So I'm not sure I'm thrilled.
Well, what's your suggestion of moving?
Well, the problem is, to keep the trial date, I don't know if we can move the dispositive motions out a week. I think at a minimum that should be pushed a week, because then we're not trying to track down.
That's really up. Williams is the one that has to read that.
Yeah, we don't have a problem kicking out a week because, like I said, I think there's so much duplication with what he's already ruled upon.
So dispositive motions January 10, Joel.
Well, we both know how he's going to rule this. We're the only ones that have been in front of him twice.
I think they read the other transcript.
January 10 for that.
Yeah, I think if that's okay with the court, we've got to at least move that. And the only other one that I'm worried about is the rebuttal deadline because of the Thanksgiving holiday.
So about December 2. Rebuttal on the no, are you talking about rebuttal on
the rebuttal of the specific experts on December 2 is great if the experts meet that deadline, but they're going to get the initial report on November 11th, and then they got to get their rebuttal by the 2nd of December, including the Thanksgiving holiday. That's tight. We've worked out issues like this in the past.
No, neither. I'm kicking that out.
Yeah.
What, December 9 for that?
Yeah, let's not kill ourselves. It's the 5th open trial.
Well, the judge has to read these motions. So I think what I'll do, I can send over the recommendation in order, but I'll put a letter on it saying we understand that normally I don't set the dates for dispositive motions.
Right.
And he didn't set that date when he gave you the trial?
He let us stipulate in the prior case, we moved stuff around.
Maybe we can do some kind of procedure where if it's a new motion, we put a red star on it or something,
right.
To kind of let him know what needs to be read and doesn't.
So he let you pick the dates for the last trial?
He let us push them a little bit.
Mm-hmm.
All right, then I'll do a recommendation on that. I'll do a special master order on that.
Sure.
If you want to submit it to the judge to change something, that way you can do an objection.
Okay.
Teddy Parker for the record. Joel, have you made a decision on liability for this next trial? Because that's going to cut down on a lot of the motion practice.
Yeah, there's some that we're going to agree on. There's some that we're still looking on.
Okay. Because if some of those include
Kehe, Brown, or is that talking Bonner or Brown?
Talking Brown.
Okay.
Yeah, Teddy and I have been talking about liability in the Brown 15 group.
Okay. My thought is, since we are going to be moving right into the next case right after that, give that some thought in terms of Bonner as well.
Yeah.
Because that will cut down on all the quite a bit of the dispositive motions as well as the MILs in front of Judge Williams.
Yeah, that's true.
All right, thanks.
Is that it?
That's it for me.
Kelly, did you need any names or spelling or anything?
Yes, sir. I did want to know, I can't see really well into the room. I know your name is Joel. Sir, what's your last name?
Odou, O-D-O-U.
O-D-O-U. And who is sitting to the right of Art?
Ashley Gugino.
Okie dokie. That's what I needed.
All right, anything else?
No, sir. I'm good.
All right, thanks, everyone.
Thank you.
That's okay.